Welcome once again to Lehto's Law. Here's Steve Lehto.
I've spoken with the Institute for Justice lately on my channel, and they are an organization that do great work. They often take up causes on behalf of people who could not afford lawyers otherwise, and quite often they're constitutional issues. And I had a few people back in the day, I'm talking about a few months ago, send me a case and say, Steve, did you see this case? It was decided just about a month or two ago, but it's a big constitutional issue. I had not talked about it on this channel yet. And the other day, the Institute for Justice said, Steve, would you like to be a guest on our podcast? And I said, sure. They said, well, what we do is we have guests pick a case that they know something about and come on and talk about it. And then we discuss it amongst ourselves. There's 3 attorneys in the podcast. You'll be one of them. And I said, great, I will do this case. And it's the case of Wood versus Eubanks. It's out of Ohio. It's a free speech case involving the First Amendment. And I have not done this yet on my channel. So I discussed it on the podcast with the Institute for Justice. And I think I discussed it there a little different than I'll discuss it here. But if you get a chance, go check out the podcast. It should be up by now. And when it goes up, I'll put a link in the box below the video. But this is an interesting case. And I have to tell you right now, I will have to censor myself heavily. And I'm doing it for 2 reasons. One of which is YouTube's got standards on language. Number 2, I worked in radio for 20 years. And I have trained myself to not use foul language within 100 yards of a microphone. I will burst into flames if I were to use these words out loud. Now, the flaming thing might not be quite literal, but the point is that when I see these words on paper, my brain says, don't say that word. So I'm going to have to clean this up quite a bit, but you will understand what I'm saying. But the story basically boils down to this. A man named Michael Andrew Wood, who's the plaintiff in this case and the appellant, went to a county fair in Ohio wearing a shirt that said F the police. And F stands for a word, and on his shirt it used the entire word. Now, as I pointed out to the guys at the Institute for Justice, it's also the name of a song by NWA, and it's off of an album I actually bought back when I was in law school because it had a couple of really good songs on it. Very, very early rap guys. But F the Police was the name of a song, but I don't know if that's where the term was meant to refer to on the man's shirt, but he's wearing a shirt that says F the Police. He goes to the county fair, pays $3, gets in, goes to the county fair. He's walking around. Somebody sees a shirt and they're bothered by it. And they complain to somebody, and we don't know exactly the order in which these things happen, but somebody complained about the shirt, and it was brought to the attention of the guy who's running the county fair, as well as the police. So eventually, the police and the executive director of the Clark County Fairgrounds shows up, and they confront the man. Interestingly enough, he's not wearing the shirt anymore. We don't know if he changed it, turned it inside out, or put something over it, but he's no longer wearing the shirt. And the executive director of the fair and the cops walk up to him and go, where's the shirt? I want to see the shirt. And the entire exchange is recorded on body cams because there's 6 cops who wind up getting involved in this story. 6 cops. And so at one point, the executive director of the fair goes, I want you out of here. You've got to leave. I'm ejecting you from the fair. And he argues with them and points out, he goes, hey, look, this is a public fair. I paid to get in. It's taxpayer dollars that paid for the fair. It's not your fair. I think I should be allowed to stay. And the guy goes, no, you can't stay. You got to leave. I'm kicking you out. And the police, by the way, are going to escort you out if you don't leave. So he puts up a little bit of a protest about that. And he says, what about my $3? Fair director gives him his money back. Actually flips him a 5, and they have a little argument about whether or not he should get changed. The guy actually offered to give the $2 back, and the fair director goes, nope, that's okay. I don't want your money. Well, so anyways, they start bickering back and forth. And I'm being nice when I say bickering because the language escalates. It escalates. So at one point in time, Wood says, I'll be talking to my attorney about this. And he says that because he said, even though he'd taken the shirt off, that wearing the shirt that says F the police is a constitutionally protected activity. And he's basically saying it's a First Amendment right to say something that you have on your mind, particularly when it's criticism or political in nature. Criticism of those in power. And F the police obviously is criticism of those in power. So the police go, you have to leave now. And he asks him, is that a lawful order? And the discussion, like I said, degenerates pretty quickly because as they're walking off the property, Wood refers to the police officers as thugs, mother effers, 6 bitch-ass effing pigs, effing thugs, F all of you, you dirty rat bastards, effing thief, effing thugs with badges, and literally page after page after page of insults that he's hurling at these police officers. But it's important to remember that there's 2 things at stake here, 2 things in question. One is the shirt that had a statement on it, F the police, and the verbal statements this guy is saying right now. And he's simply saying things like, you guys are pigs, you guys are thugs, you guys are effing pigs, you guys are effing thugs. He's never threatening them. He's never threatening anybody with violence. He's not doing anything other than just insults. Just insults. They're insults, okay? And he says these things, and at one point there are 6 police officers surrounding him. 6 police officers and the fair director. They start walking out. Cops go, come on, let's go this way. And he goes, no, I'm out back. I'm going that way. So they walk him to the back gate. And at the back gate, the fair director keeps saying, I want him arrested. I want him arrested. Arrest him. Charge him with something. And I think at one point they even said, charge him with something. So they arrested him. And they said they're arresting him for disorderly conduct and disturbing the peace. And those 2 under Ohio statute apparently are pretty much the same thing, or they're subparts of each other. And as this court points out, that you get into federal court on a lawsuit, there's going to be both state law and federal law involved. We'll get that in a second. So this man, they arrest him for disorderly conduct, take him to the police station, book him, do all that stuff, and then they decide not to prosecute him. Prosecutor looks at the case and goes, there's no case here. Dismisses the case. Now, they claim the case was dismissed due to a lack of witnesses, which is the kind of thing that you look at and go, you do understand you can call cops as witnesses. So you've got the fair director and 6 cops. You got 7 witnesses there, my friend. 7 witnesses who saw the whole thing. Unless you want to talk about the F the police shirt. But is that really why the guy was arrested, for wearing a shirt before you saw him when he wasn't wearing the shirt? So they dismissed the charges. And they said, and this is the quote, the state was unable to locate necessary lay witnesses to the incident in time for trial. So I guess they're describing the incident as the shirt that says F the police. In court, the police say, well, we've got qualified immunity. You can't sue us. We were just doing our jobs. We arrested a guy, and because the charges were dismissed, you can't just sue us because the charges were dismissed. We've got qualified immunity. And we've discussed qualified immunity before, and the problem with qualified immunity, of course, is that you've got to point to a specific right you have that was violated by the police, and the police should have been on notice of it due to other case law in your circuit. And this is the 6th Circuit, which includes Michigan. And the interesting thing about this case is that the Court of Appeals, the 6th Circuit, says the right to not be arrested, the right against false arrest, is well known, well established, and if a police officer falsely arrests you, he loses qualified immunity. But the problem is that the trial court didn't see it that way. The trial court dismissed the case entirely based on qualified immunity. So the man goes to the fair, gets arrested, charges are dropped, he sues the police department, and the trial court says you can't sue him, qualified immunity, and throws it out. Court of Appeals reinstates, sends it back down, and says no. Qualified immunity goes out the window because police should know of all the things that police can get away with not knowing. The one thing they should know is when you can arrest somebody. That's basically job number 1, right? Police show up and they look around, they investigate, and the first thing they do if they think there's a crime committed is arrest somebody. They should know how to make an arrest. That's well established. So the court says specifically the only issue is whether the officers had probable cause to arrest Wood for disorderly conduct because his right to be free from arrest is clearly established. If so, the officers are not entitled to qualified immunity. So you back up now to the facts as we know them because there were 6 body cameras recording everything. And it's hilarious to read this opinion. And by the way, I'd recommend you read it. It's only 18 pages, trust me, which is short for a federal appeals court opinion. And they go into a discussion about what the law is in Ohio on disorderly conduct, and then what the elements of probable cause are with respect to the Constitution. And the idea of disorderly conduct cannot simply be that you said something that made people uncomfortable, because we do have the right to free speech in America. And I've seen people holding up signs that I disagree with, but they're allowed to do it because this is America. And I've seen people wearing shirts I disagree with. I've seen people wearing styles I disagree with, but that's another story. And the court goes into an extremely good explanation of how this has evolved over time and came to the conclusion that pretty much, if we're simply talking about words, that is, words not coupled with a threat. If I walk up to you and say, I'm going to punch you in the head, and I raise my fist like this, and you complained to the police and said he raised his fist, acted like he's going to punch me, said, I'm going to punch you in the head, I wouldn't be getting arrested there for the words I spoke. I'd be getting arrested there for the threat coupled with the apparent ability to carry out the threat. This right here becomes the important part. If I simply said, I'm going to punch you in the head, and I'm, say, 30 feet away from you, it's not even a threat. I can't punch you from 30 feet away. And so they have to look at the words, because this man never threatened anybody. All he said was a series of insults. And the court points out that pretty much nowadays, if we're simply talking about just language, just words, okay, somebody said something, the only exception that can get you in trouble there, for the most part, is fighting words. And trust me, if I wanted to, I could walk up to you, get in your face, and say something to you so vile and so foul that you'd want to immediately punch me without even thinking about it. And most people can do that. They wanted to. They don't want to, but they could if they wanted to. Where you walk up to say somebody and you say something so evil and so mean that it's going to provoke them. And so if you say something like that, it's called constituting fighting words. And even there, the court points out that the fighting words doctrine goes back to 1942, and then points out that the fighting words doctrine has become very limited, and standards of decorum have changed dramatically since 1942. In 1942, what was accepted in polite society is very different than what we accept nowadays. And so the mere fact that somebody is insulting you or calling you names will not rise to the level for which you can be arrested. Okay, just simply saying words, saying insults. And so here's the thing. The court points out that police officers are expected to exercise greater restraint in response than the average citizen. And that's the whole point, is that you know, if you're a police officer, you're going to encounter people who don't like you because of your job. And you might think, that's not fair, they don't know me. I have people who say they don't like lawyers, therefore they don't like me. But you don't know me. You don't know. That's okay. I knew going in before I was an attorney. I remember people saying, oh, you become an attorney? That's too bad. But the point is that if you become a cop, you should know that people aren't going to like you. And so just to remind you, there are reams of case law on the idea that you can flip a cop off. And by flipping him off, I mean extending a middle finger towards him in an attempt to, not provoke him, but an attempt to insult him or to express your indignation, whatever you want to call it. And they actually say here, we're talking about fits of rudeness or lack of gratitude may violate the golden rule, but are not illegal, punishable, or for that matter, grounds for a seizure. And they refer there to a case where someone extended a middle finger to a police officer. And the police officer then stopped the car of the guy and then charged him with something. And guess what? Extending your middle finger is protected First Amendment speech. Now, here's the deal. There are going to be people in my audience who are going to say, Steve, are you encouraging people to go flip off cops? No, I'm not. Steve, have you ever flipped off a cop? No, I have not. Will you ever? I doubt it. And there's a whole bunch of reasons for that. But one of them is that number one, I'm not that fired up against cops to do that. I've done stories about cops and bad cops and so on. But let's say you flip off a cop and you're in traffic, and he pulls you over and spends 20 minutes asking you questions and lets you go. You could theoretically file a complaint and possibly try to sue them and say that the guy stopped you for no reason. And of course, he's going to come up with a reason as to why he stopped you. So we've all heard the story, you might beat the rap, you can't beat the ride. Well, here you can't beat the being pulled over. But whether or not it's a wise thing to do, I would say it's not. Is it illegal? No. And there have been cases on that in many districts across the nation. But you should know that there have been examples where people have done that in conjunction with saying something or acting in a threatening fashion. So if I was face to face with a police officer and I stuck my hand right in his face and did that, still probably okay. But then if I said something like, I'm going to rip your head off, well, then that's a problem because it's coupled with a threat. And in this case, the Court of Appeals referred to a case where somebody had actually insulted the police officer while saying, I'll rip your head off. And that was not considered protected speech because it was a threat coupled with the apparent ability to carry it out. So it's an interesting case. And one thing I do want to point out very, very carefully here, because there are going to be a lot of people in the audience who are going to jump to a conclusion and say, oh, this guy won his case. Congratulations, he's a winner. Unfortunately, he is not. He has simply overcome the first hurdle. So in litigation, someone files a lawsuit, and if it survives the litigation, it goes to trial, or it can settle before going to trial. But the two ways you would win is if you went to trial and won, or you settled on terms favorable to you. So there's two good outcomes that you can have: winning the case at trial or settling the case, terms good to you. Several ways you can lose. You can go to trial and lose. We'll get to that in a second. Or your case can get thrown out for a variety of reasons. Now, the most obvious reason that your case can get thrown out in a police case is qualified immunity. So they got his case thrown out. And trust me, they were celebrating back when they got that done. But it's now been reinstated by the Sixth Circuit Court of Appeals. So all that means is he gets to go back to court and litigate and then go to trial. So he's back to square, not one, but square two. So he's still got to go ahead. And here is the big question I have, and this is something I am curious about. Let's suppose that the man says, I'm going to pursue my case back in court. Now we're going to pursue the case. And the parties get together at a settlement conference, and both sides or either side says, no, we're not going to settle. We are going to trial, my friend, going to trial. It's a lawsuit. So you're going to go to court. You're going to pick a jury. You're going to pick a jury of people from that area who are in that district of that federal court, and they'll serve on the jury. And you're going to say, I was arrested at the county fair. And by the way, we don't have to describe anything to you. We can show you the entire event filmed from 6 different body cameras. I think all the cops had body cameras, but I know there's more than one. Several body cameras all showing the same event, Matrix style, from different angles and elevations. Okay? I'm assuming some cops are taller than others. So you're going to see what happened. There's no need for anyone to get up there and say, well, he said this and he said that and he said that. I mean, that's going to come out through testimony. But a lot of this is simply going to be the jury watching what happened. And so the question I have for you, and this is hypothetical, is ask yourself realistically, if you were sitting on a jury with a bunch of people from your neighborhood, not your buddies and your pals, I'm talking about your next door neighbor, who might be a church-going woman, it might be a heavy drinking guy, we don't know. Just a bunch of random people like that on a jury. And they get to watch a video of a man talking to the police, saying, look at these thugs with badges behind me. How many is there? You mother effers, 6 bitch-ass effing pigs. Effing thugs with guns. Don't uphold the Constitution. F all of you, you dirty rat bastards. Effing thief. Effing thugs. Thugs with badges. And by the way, I'm leaving out 3/4 of it. There's much, much more here. There's literally paragraph and paragraph, pages of this, okay? And I've seen videos like this on YouTube of guys who are doing First Amendment audits. And they say these things to police officers and film it to show that they can do that. It's great. What happens when instead of being on YouTube, it's in front of a jury in a federal district court? And the man's going to go, I was wrongfully arrested. I want compensation for that. There is a chance that a juror could say, still it was self-inflicted. You did all of those things and said all of those things, and yes, they're constitutionally protected to say those things, but when you're spewing this kind of stuff and the owner, operator of the facility is saying, arrest that man, he was causing a disturbance, the judge will instruct the jury that they didn't have the right to arrest him. But the jury is going to be asked, was it a wrongful arrest? And if so, how much are his damages? And that is where I think a lot of people really miss what could happen here. Because a jury could look at this and go, well, if he'd simply been walking through the fair wearing the shirt, he took the shirt off and they arrested him for that? Yeah, that's a bad, bad case to be arrested for. But he's walking through the fair, takes his shirt off, they confront him, and he starts mouthing off to him in just a stream of consciousness tirade of obscenities, foul language. Yes, it's protected, and the court will tell the jury this. By the way, those words, you might not like them, but they're protected free speech. But they'll still be asked, what are his damages? How much do you award him for this? And I've seen juries, in my 31 years of practice, I've seen juries who look at something and say, okay, we owe this person something, but what happened to them was kind of self-inflicted. Therefore, we're not going to give them as much. So I would be curious, and believe it or not, if you said, Steve, if you could pick an outcome for this case, what would it be? Because it could settle where no one says what the terms are. We don't know if he got money, he may have, he might not have. It could settle. It could still get thrown out by a court on some other grounds, okay? It could get thrown out on other grounds. So for instance, I'll give you an example. In the footnote to this case, the police tried to argue and say, through their attorneys, that we could have arrested him because he disobeyed our orders. We said go out the front gate, he said I'm going out the back gate. And this court on appeal said it was not raised at the trial court. Therefore, we're not even going to go there. So there's always possibilities of other arguments being raised. If you said, Steve, what would you like to see? I would love to see this go to trial. Full-blown jury trial all the way to a verdict. That's what I want to see because I'm fascinated by this case. I've seen a lot of these types of cases out there. And unfortunately, a lot of them settle. And when they settle, we don't know what would have happened. And so it would be nice to see one of these cases go all the way through the process to a jury verdict, see who they rule for, and see how much money they award, if any, to the plaintiff if he prevails. So we'll see. And like I said, it's just being sent back down now to the trial court for further proceedings. So that's the case of Wood versus Eubanks. It happened in Ohio. 18-page opinion. I'll put a link to that also in the description below. And if you've got questions or comments, fire them away. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. The less you try to impress, the more peaceful you can be.